Hey, good morning, everyone. We're just going to wait a few more seconds to let everyone in from the waiting room, and then we will get started. That seems good enough for now. Chelsea will keep letting people in and they can catch up. So, good morning. Welcome to today's Zoom Q&A. As always, in the chat, you'll see a little blurb directing you to our YouTube channel and also where to send questions to by Monday of the week of the Q&A at 4 p.m. Just a reminder, we are not having Q&As on the 24th or the 31st. So our last one of the year will be next Wednesday at 10 a.m., which is the 17th. So we will be meeting next week, but that'll be it until 2026, which means that this is our second to last chance to remind everyone of the changes that will be effective January 1st, 2026. The big ones that we've been talking about are the changes to the meetings statute for a lot of communities, changes for everyone, but more notable changes for some condos and old act condos regarding open meetings and some changes related to collections notices. There are new limits on the amount of late fees and admin fees that you have to basically wait for until you send your pre-foreclosure notice, and there's specific notices you have to provide. There's also a cap on late fees of no more than $50 or 5% of the delinquent amount for that first late fee, whichever is less. So again, that goes into effect January 1st, 2026. And then, as always, this is general information. It's not legal advice. The chat is intended for questions or requests for clarification. It's not more legal advice. Y'all are pretty respectful, so keep it up. That being said, we do not have a lot of questions today, so we will have time for questions in the chat. We may not answer some if they are too specific or asking for legal advice, but we will do our best to answer them generally. Again, if we don't get to them, feel free to submit them to info@condolaw.net by next Monday at 4 p.m. And with that, we will jump into it. Before we get into our first questions for today that were submitted in advance, we did want to address the massive amount of water that has been falling from the sky the past few days. And note that with all the rain and flooding in some of the local Seattle and surrounding areas, to remind everyone to stop the leak first. Meaning some of you may not have problems, but some of you might have already noticed leaks from the roof or there's been flooding. Given all of that, and if we get a freeze event and there's a leak from that, stop the leak first and then figure out who pays and who is responsible for the repairs. The most important thing is to stop the leak. I can't emphasize it enough. Even if you're in the middle of repairs for something else and there's a lack of weatherproofing or something, do whatever you need to do to keep the water out. If that means sandbags to prevent flooding, get the sandbags. If that means tarping the roof, tarp the roof. Again, you can figure out who pays for what, or even what remediation work needs to be done later, but you need to mitigate and stop the damage. There are modern amendments that may make owners responsible for the deductible or costs, even if there's no fault of the owner. That's great, but stop the leak and then figure it out. Um, so that's just our we're in a bad weather system warning. Ken, do you want to add anything before we jump in?
No, I think that is important. We have a lot of clients that will, I don't know, I'll say for some reason, because they don't know the best way to stop the leak, will not do anything. And, I have told clients before, if you don't have any other way to do it, put a blue tarp on the top of the building. Uh, the blue tarp will meet the client or the association's obligation to stop the leak and stop the damage. And we had one just this last week where the association is in the middle of repairing a door on the building because water had been coming in. And the contractor's been out working, and one of the owners stopped by to see the work and found water inside the unit. And uh, our response to the board and the contractor was find a way to stop the water getting into the unit, even though you're in the middle of repair. Put another tarp up, go out, do something temporary, because the water coming into the unit is causing damage. And yeah, it's the urgency to stop the water damage sort of terminates with once you've got the leak stopped and have extracted any water that's causing damage to the structure. So you may need to have a company come and vacuum up all the water inside. Maybe you need some dehumidifiers, but you don't have to do a repair in a panic. We had a client a few years back where there was a really significant rainfall event up in Mukilteo. Maybe I think they said something like an inch of rain fell in the span of an hour. And so the landscaping around the buildings was overwhelmed with water, and water came in the sliding glass doors for something like 20 units. And the board immediately hired a contractor to come and fix all 20 units. The contractor spent 3 months and then presented a bill for $500,000, for which there was no insurance coverage because it was a flood. And floods don't have insurance coverage under a standard property policy. And what they should have done was stop the water, vacuumed up all the water, and then stop to get some more reasonable bids for the interior repairs. So, it is two distinct separate things. One is stopping the leak and eliminating any immediate damage. The second phase, which you can take time to do, is to manage the repair process. Anyway, thanks, Katie.
All right. So our first question submitted in advance, I believe we answered this last week, but we're just going to do a quick recap, is if an audit is performed on an HOA and you find that a homeowner has not been charged their assessments, is it okay to backdate and charge accordingly for their dues? So first, this is too specific for us to answer and provide legal advice on in this setting. You should contact your association attorney regarding your specific situation because there are other factors that we don't know about and can't answer about for what is legal or what is reasonable. One is we don't know how much time has passed. That may affect the answer. If it was more than a year, that matters. If the owner paid this year and then stopped paying, that's going to give a different answer. If they've never paid and it's been 16 years, that will also impact the answer. So, like I said, we can't answer it fully. The assessments are typically due in accordance with the budget ratification notice. So, the budget ratification notice says the date, and the exact amount of the assessment that's due. If they don't follow that, then, as we all know, there's usually a delinquency. Usually. If the owner has not paid, then they might still owe the assessment and it should be reflected on the ledger. But again, it will depend if they've never paid, how long they've never paid, did they pay this year and then stop? So, like I said, contact your association attorney. And it may also depend why the assessment was not made. Was there a change in management and there was an auto pay that then stopped? You should talk to your association attorney about if it's reasonable to waive late fees and interest, even if the assessment is still due, because it may not have been the fault of the owner. So, a lot of things to consider. Um, and if the owner didn't even know they owed an assessment, that will also play into whether or not it's reasonable or okay to charge back. So that's a long way of saying there are a lot of things we don't know. We can't answer this question, but those are some things to consider and what you should talk to your association attorney about if this is a situation you find yourself in. Anything to add, Ken?
No, I think you I think you covered it. So the second question is regarding email addresses and the requirement to disclose them under Ukiah section 6490, 495. So there is a requirement that the association keep a list of owners and the address that the association uses to communicate with the owners, and the number of votes that each owner has. And that is a list which the association is required to give to any owner who requests it. The owner, if they have opted into electronic notice, would be using an email address for the communication with the association. And so the statute was revised in 2024 to say that the email address can be withheld from distribution to all the other owners if the owner has requested that the email address be kept confidential. And that's the wording in the statute, is the confidential part. And so the association would be required to provide the mailing addresses for those owners that they are mailing to, and the email address for those owners they are emailing notice to, but withholding those who have requested that the email address be kept confidential. And in that second case, if it's being kept confidential, the association would still provide a mailing address. Now, further in the statute, which the question is about, is a section that says that you do not provide the email address of any resident. Now, I don't believe that the legislature would require that you give the email address of an owner and then be able to use that as a exception to providing it for an owner who is also a resident. But I do think it means that if you've got email addresses for two owners of the same unit, you only have to provide the one which the owner has designated as the single address for providing legal notice. And if you've got tenants in the building, you do not provide any of the email addresses for tenants because they are not owners. So we have just started to have owners who are at least threatening litigation over what email addresses are provided and what email addresses are not provided. And I'm guessing that we're going to see in the next probably year or two an appellate decision come out over whether or not an owner is entitled to the email addresses of all of the other residents, or whether the requests for confidentiality apply or not. There is certainly some confusion or different ways of reading the statute right now, in terms of the timing of a request and the contents of that list of owners, whether it's as of the date that the list is provided or the date that the list was requested. And so I'm guessing we're going to see some courts resolve some of those things. But I guess part of the takeaway for me is that we recommend that all of our clients, if you are trying to get the permission from owners to use email for notice so that you can save on mailing costs, and I haven't met a management company that didn't want to do that yet. But if you're doing that, that you also, at the same time as you are requesting electronic notice privileges, you ask the owner if that email address should be kept confidential. Because if you have not asked and they have not independently requested that it be kept confidential, we think you're going to be required to provide that email address for any owner who is opted into electronic notice, because that is the email address the association is using to communicate with the owner. So, did you have anything you want to add on that, Katie?
The only thing I'd add is we did also talk about this at the start of our last Zoom. So if you feel like you have more questions about it, feel free to look at that recording as well. But with that, I think we can move on to the next one. If the board does not update the professionals reserve study, is it okay for the budget package to state that the association has a reserve study that meets the requirements of RCW 6438065? So first, as an initial statement, 6438065 should have no application because Ukiah under 6490545 applies to all communities regardless of their creation date. Both statutes, um, and I guess the list of in RCW 6490550, that says what should be in a reserve study without a fine-tooth comb. It's pretty similar to what's in 6438065. I don't have a track changes comparison, but for the most part, they're the same. I don't think there's any major differences. If the question is asking, if the board did not update the professionals reserve study, meaning they just voted to accept the reserve study professional's opinion for whatever this year is, then it's okay to say in the budget that the reserve study meets the requirements of the statute if the reserve study actually meets the requirements of the statute. If the question is asking if the board did not update the reserve study for the last year, and it was supposed to, as required by statute, need to be updated every year, meaning you just did nothing, there have been no updates, then no, you cannot state in your budget that the association has a reserve study that meets the statute because an out-of-date reserve study cannot comply with the statute. Meaning the statute requires that you have every year you update your reserve study. And then on the third year, you have to have a site inspection by a reserve study professional. So if you've done no updates for the last year, again, that does not comply. There may be times, even if you've updated it within the last year, that the reserve study still doesn't comply with the statute. 6490550 can be used as a checklist for what the reserve study must include. And there are times, even if a professional produces a reserve study, that it doesn't comply with the statute. We commonly see that reserve studies do not include a per unit deficit or surplus based on allocated interest. So if you have varying amounts of allocated interest and dues, your reserve study needs to state how much each unit there is a surplus or a deficit. If everyone's the same, then you can have one number. But that's a common thing that we see lacking. There may be other things. Again, use the statute as a checklist, because if it doesn't comply with the statute, then you need a statement that says the reserve study does not comply. Ken, do you want to add anything as a former reserve professional?
Well, we do have a lot of clients who will tell us that nothing has changed from the prior year, so therefore they don't need to update it. It's still current. And that may be true with regard to the components and when they need to be repaired, but it's not going to be true regarding your bank balances. So if you've made any contributions to your reserve account or you earned any interest, then the dollar amounts that you have in reserves will be different. And so at a minimum, you can update the reserve study to reflect the current bank balance, and that will change perhaps things like the percent of your fully funded balance, or how well funded you are, and it will affect the deficit or surplus. So the interim years between the required 3-year visit from a professional, you can do relatively simple adjustments just to reflect your current bank balance. And if you actually have performed a repair, you might want to reflect that in the study as well. It doesn't require that you hire anyone to do it. Managers could do those interim updates. Board members, treasurers can do those interim updates. There's also not a lot of harm for checking the box that the reserve study does not comply when you give your budget notice. If you're not sure, just check the box no, because it's not going to make any difference for whether or not your new budget can be ratified. And my guess is that no one of your members is going to even notice or question that you've checked the box no. So that's all I would have. Next question is, can you cite the statutory legislation or case law that prevents condo boards from restricting smoking inside a unit by a board vote or resolution? I'm aware that this topic has been covered many times. Your answers always point to the requirement for an amendment to the declaration. Okay? But then your book from 2019, I remember that 6 years ago, indicates that a board resolution may not be able or may not be enforceable to prevent smoking in units, as opposed to stating it cannot be enforceable. So this is kind of like trying to prove something doesn't exist. And so I'm going to start with just a general principle of law, which is that under, common law and certainly Washington law, the default for any property owner is that they can do anything they want with their property with no restrictions unless there is a law or a covenant imposed to restrict that use. And so the starting point would be that owners are free to smoke in their units. And Washington State does have a law which says you can't do anything in your property, which is a nuisance. But then nuisance is defined by the law, and the Washington courts at the appellate level have declared that cigarette smoke is not a nuisance. It may annoy you, but it is not a nuisance under the law, and therefore cannot be, restricted legally. Declarations are voluntary restrictions on use of property, so they can limit an owner's use of property because the owners agreed to the restrictions in the declaration. But then the Condo Act specifies very specifically in 6434 264-4 that any restriction on the use of a unit requires the approval of the affected unit and 90% of all owners. So to some extent, I'm a little confused at the question because in our mind, it is really, really clear that you cannot put a restriction on use without having an amendment to the declaration. The board can't just decide that they're going to limit the number of pets you can have by rule. They can't decide to prohibit smoking. They actually can't restrict the use to rental or commercial use unless there's something already in the document that is fairly specific to that restriction on use in place already. And there are a lot of restrictions on use related to animals, related to business use of a unit, related to rentals. But most condo declarations don't start out with anything that is restricting the use of a unit regarding smoking. Now, that doesn't mean that if there is a actual nuisance of some sort, that you can't have a rule about it. So you can have rules about noise because that is a reasonable thing for the association to do. But I don't know that that extends to a rule about smoking. So I don't know if you want to add anything, Katie, or have thoughts on that.
No, I think you covered it. With that, we have one question before we can get to chat questions, and there are no chat questions. So you have one question to start thinking of things, or we will give everyone probably a good half an hour of their morning back. So the choice is yours. But with that, the last question in advance is when we updated our CC&Rs and bylaws back in 2009, I know for sure that we filed the CC&Rs with the county, but I'm not 100% sure the bylaws were included in the filing. Is there any reason why our 2009 bylaws wouldn't be valid and shouldn't be supplied to our owners? So first, bylaws are typically not recorded. So the fact that you didn't file them with the county in 2009 is probably fine. And that's probably why you can't find them online, is because you don't normally record them. Unless the bylaws were previously recorded, which you would be able to see when you search the public record, non-recorded bylaws are effective if they were properly approved by the owners. So without looking at your bylaws, we can't say if they're valid because we don't know if they were recorded in advance and then they needed to be then recorded in 2009. But like I said, the failure to record them likely does not make them any less valid, and you can give them to your owners.
Yeah, so I would add that bylaws relate to the governance of the community, how the community makes decisions, how they hold meetings, how they vote. It's not related to the use of the property. Documents related to use of the property, like CC&Rs, get recorded with the county. Your article of incorporation to make your business entity do not get recorded. They're filed with the Secretary of State, which is a whole different legal entity. And the bylaws are generally simply an extension of the articles of incorporation. They are helping explain the number of board members, their terms, voting rights of the owners, etc. So, as Katie said, they're almost never recorded. But we have seen some CC&Rs that included a set of bylaws in them, which got recorded. And we have seen some communities record their bylaws. And then we end up with some strange smattering of clients who will record an amendment to the bylaws without recording the body of the bylaws. And, the county will record anything you hand them and pay a fee for. They don't generally read them or consider whether it's reasonable or not. They just take the fee and record the document for you. So it certainly wouldn't hurt to at least occasionally look at what documents are recorded for your community. And if you're not sure, you can have a title company pull a report for your lot, or look at the documents you got when you purchased your community property, because it will have a list of all the documents recorded with the county for your particular unit or for your lot, and you can make sure you have all of those documents. So,
I'd add that if your bylaws have been recorded and you don't want them to be anymore, because every time you update your bylaws, you would then have to record it just like an amendment of the declaration. It is possible to rescind the recording of the bylaws, which is something that is not uncommon for our office to do when doing restatements, just to make the whole bylaws process easier, because it does not need to be recorded to be effective. And with that, there is a question in the chat, which is, when an association has too few directors and can't do everything it would if it had all directors, what is mandatory for the directors to do? So we can't tell you exactly what you need to do, but we can give some general information. You, one, can appoint additional directors to help fill out the board. Like I said, we don't know your situation, how many you have or how many you need, but the directors remaining, say everyone resigned except one, the directors remaining still have an obligation to basically help keep the association afloat. So things like paying the electric bill, probably reasonable to keep doing. What you probably can't do is a major construction repair that's completely out of the blue. But we don't know if it would be necessary or what circumstances may warrant that. So Ken, I don't know if you want to elaborate on anything, but you have to do the bare minimum to keep the association functioning. And what that means may differ for communities.
well, part of I guess I would want to know whether they're talking about having a full board or just enough to be a quorum. Because if you were supposed to have a board of 5 and you've only got 3, those 3 have all the power to do everything that the full board could have done. There are fewer people voting. If you needed a board of 5 and you only have 1 director, then usually I would caution the 1 director to limit what they are doing because it's difficult to establish that they are, uh, I'll say, collectively doing what is reasonable for the association. And it is a challenge when you've only got one person willing to step up and volunteer. And we had one client looking at trying to manage a $250,000 repair. And it was a big community. I mean, I think it was over 50 units, and couldn't get any one other owner to step up and help him so that in hindsight, it would be easy for anyone to look at the process and say it had been fair and reasonable. So our advice was, to the extent that it wasn't an emergency, just hold off on the repair. Uh, the more necessary a function is, like acquiring insurance or paying utility bills, then the more routine it can be and the less risk for a board of one or even a manager who can't get a board member to step up at all to go ahead and do the work anyway. But I think it is, to some extent, you send out a scary letter to all the owners, telling them that if no one steps up to just rubber stamp the recommendations of the management company or to make the minimal decisions to buy insurance and pay utility bills, then the association is going to end up with much more in the way of expenses. And usually somebody will step up to just save that bit of money.
All right, our next question is a two-parter, and I think some of it may be too specific, but I'll read it and you can decide. So it's about documentation for collection decisions. The first one is, when initiating collections, what identifying information is permissible for documenting the board's decision if our software does not provide for an account number? For example, may we reference the lot number, parcel number, or other property identifier? So for that, Washington does not have any specific protections for dealing with protecting the identity of delinquent accounts. Meaning, if you wanted, you could use the last name of the person to identify the collection action. We don't know what your software looks like, but for the most part, we see last name and lot number. If you don't want to use the last name, lot number, so you know where it is. But I don't know, Ken, if I would defer to our collection attorney on this one, but I don't know if Ken has a different opinion.
I think that we have a lot of clients who are very concerned about revealing the name of delinquent owners. And as Katie said, there's really no law that says you can't reveal the name of the delinquent owner. I don't want you publicly shaming them, but if it's in the board meeting report because the software spits out a list of delinquent owners and it uses the name of the owner and the lot number, that's fine. It can be in your board report, and the board can, use the lot number for reference. It's not like a really nosy owner couldn't go get all the information if they wanted, because they are entitled to the records of the association in an unredacted form. At least that particular record, in my opinion. So, don't go out of your way to embarrass people, but I don't see a reason why you couldn't just conduct a business using the lot numbers and names if you need to.
And I think you answered the second part of the question, which is, if a community member requests to know which lot or owner is delinquent, what information, if any, is legally permissible for the association to disclose? So I think we touched on that. There are competing arguments that you are allowed to withhold or redact information that is exclusively in the non-requesting owner's unit file. I don't think that delinquency information falls under that exception, but there is an argument that some people make that it does. I still think you would have to provide basically the account information, even if you redact the owner's name. But I don't know if Ken, you have a different.
Yeah, I think there's a difference between a a violation notice in a unit owner's file, which I think you would have to redact, and the delinquency information, which is on the accounting records, which are not specific to an individual unit. And in part because the delinquent owner can solve the problem by just paying their dues. We haven't seen any litigation on this issue, so that doesn't help us. We have no guidance, but what we think is reasonable.
And with that, that was the last question in the chat. So unless one pops up before I finish this sentence, feel free to submit any questions to info@condolaw.net by 4 o'clock next Monday, and enjoy the 24 minutes extra of your day that you have now. See you all next week.